Sebi 3 months to conclude its ongoing investigation in the matter. A 3-judge bench led by Chief Justice D.Y. Chandrachud further allowed Sebi to assess any violation of norms by the Hindenburg report. Remember, the US-based short seller had accused the Adani group of stock manipulation in January last year. Ashwin Kumar is here with all the details. He was there in the Supreme Court. He has been tracking this major case with implications for the stock markets, for the regulators for the last few months. He takes us through the key contours of the judgment from the Apex Court.
Well, fresh out of the winter break, the Supreme Court dived straight into the midst of action, coming out with the much-awaited verdict in the Adani-Hindenburg saga. Here are the important takeaways. Number one, the Supreme Court records in its judgment that Sebi had launched 24 cases of investigations into issues raised by the Hindenburg report. The Supreme Court records that out of 24, probe has been completed in 22. The Supreme Court has directed for the remaining 2 to be completed in 3 months' time. The 22 probes which have been completed, Supreme Court has directed for them to be taken to their logical conclusion. Number 2, the petitioners had sought for the issue to be investigated by the CBI. They had also sought for a court-appointed SIT to probe the allegations. The Supreme Court has given an unequivocal no. The Supreme Court held that no case has been made out for transfer to the CBI. The Supreme Court also recorded in its order that report by third parties like Hindenburg and OCCRP cannot be treated as gospel truth. Number 3, the petitioners had raised allegations of conflict of interest against members of the expert committee appointed by the top court. The Supreme Court has rejected these claims by the petitioners. The Supreme Court held that no case of conflict of interest has been made out. Number 4, on the issue of regulatory framework, the Supreme Court noted that as opposed to petitioners' claims that FPI norms were diluted to allow mischief, the disclosure norms were rather tightened. The Supreme Court held that no grounds were made out for revocation of the amendments made to the FPI and LODR regulations. The Supreme Court has also directed the Centre and Sebi to consider the expert committee recommendations for strengthening the regulatory framework. And finally, number 5, Supreme Court has directed Sebi to probe short selling by the likes of Hindenburg. The Supreme Court has directed to probe if actions by Hindenburg may be in violation of Indian laws. The Supreme Court has also asked for suitable action in case of violations of existing regulations. Now, while findings of the Sebi investigations are not known yet, leading legal voices are pitching this verdict as an exoneration for Adani, given that no criminal probe has been directed by the top court.
Instances which have been investigated, the fact that there is an exoneration is a shot in the arm for the Adani group. As regards to that, investigation will take place, and whatever its conclusions will have to be considered by the court at the appropriate stage and a view taken. That we will have to await.
So just one word as far as the Sebi regulations are concerned. There were questions raised about the existing framework. To that end, Supreme Court very clearly has held that there is no dilution of FPI norms, rather they've been tightened. Does this perhaps give an indication of the current framework in place, or more work needs to be done? Expert committee regulations also need to go into?
As of today, the Supreme Court has appreciated the work that has been done and has therefore said that nothing further needs to be done on the regulations. In any case, the Supreme Court does not sit over a legislative exercise, which is the domain of Sebi, and that is what they have said. Having said that, in my view, keeping in view the changes in technology, keeping in view the changes in the ways of doing business, there is always need for regular upgradation of regulations, because that is the whole purpose of having delegated legislation, so the government can keep adding and making robust mechanisms to ensure that transactions and the regulatory mechanism is strong, robust, and the interest of investors is protected.
One final question, sir, on the question on the credibility of Hindenburg report, OCCRP report. Supreme Court has had some very stern observations to make that it can be only supplementing the investigation. It cannot satisfy being concrete proof.
In every mechanism, in every nation, there are regulators which operate, and once the Supreme Court has given a vote of affirmation to the functionality of Sebi as also to the regulatory mechanism, clearly the report of Sebi has to have precedence over any private reports. It is important that when private investigations come, that those may be looked at. But since Sebi has now, I would say, put a quietus to the whole issue, the matter stands resolved.
See, Sebi investigation, as I said, 22 out of 24 instances is complete. The remaining 2 will be completed in the next 3 months. But as far as the court judgment is concerned, is clearly said does not warrant any criminal investigation, including that of CBI. And it trusted Sebi to do its own investigation. So according to me, it is exoneration of the Adani group, because they have been saying that we have done nothing wrong. This Hindenburg is a malicious body which is only interested in its own profits. That's about all. So once the Supreme Court has said that no other investigation is required, if they had been guilty of some misdemeanors, the court would have ordered some criminal investigation, but that has not been ordered.
On the Hindenburg OCCRP report, the Supreme Court has said that it cannot be met as a gospel truth.
Obviously,
and that they need to be investigated.
Because, you know, that is a report which has come like ex parte, it has come from abroad, nobody has seen it, nobody has been heard, nobody has been, participate in that. So we are participating in the Sebi investigation. We also feel the Sebi is a fair and impartial body, as the court does, and therefore Sebi will decide. That's all.
So questions were raised on local regulations, existing regulations. Has that been answered?
Supreme Court has clearly said that there is no further need for the court to direct any regulations to be made. Sebi is a body, it can do whatever it wants. It has made large number of regulations. If it wants to make more, it certainly can make more.
All right, so that was the Adani Hindenburg verdict in the Supreme Court. The other big story that we are tracking, and this is with regard to the new Bharatiya Nyaya Sanhita bills. The truckers have called off their protests after the government's assurance on the new hit-and-run law in the new criminal code. As per the section 106, part 2 of the Bharatiya Nyaya Sanhita, if a death has been caused by negligent driving and the driver fails to alert the police, it will attract imprisonment of up to 10 years and a fine of 7 lakh rupees. However, if the driver reports the death, imprisonment will be reduced to 5 years, and the truck drivers have been protesting against the law, expressing concerns about the backlash from mobs and potential lynching if they don't flee the accident site. Union Home Secretary said that the clause has not been implemented as yet, and a decision will be taken only after consultation with the All India Motor Transport Congress. The two-day protest had led to massive queues outside petrol pumps as people resorted to panic buying because of fears of fuel stations running dry. Joining us to take this forward is Pinky Anand, former Additional Solicitor General of India, and Senior Advocate Sidharth Luthra. Very important to discuss the implications of this development that has happened as a result of the truckers' protest. Ms. Anand, if I can begin with you, do you think this sends out a right message that these were laws, criminal laws that were passed by Parliament? Now there have been protests by truck drivers saying that we're very concerned about the implications of the hit-and-run provisions, and they are now put in abeyance, and the government has said that we've not implemented the law right now. All concerns will be met. Does this create a confusion somewhat?
Let's be honest. When new laws come into being, and particularly you're talking about laws of such kind of standing, which can consider the entire criminal purport of the country, including, of course, the particular incident in hand. The question of implementation is always a raw. And it takes its own set of procedures, its own set of training, its own sense of sensitivities, enforcements. So, I mean, at the same time, I only feel this, that the idea of the criminal laws is to address issues of concern to the public. And when those are addressed, as they have been in Section 106 of the Bharatiya Nyaya Sanhita, you ultimately have liability on account of rash and negligent act, and also the fear of leaving somebody dying on the road without being rescued or medically treated. And these are the issues that have been addressed as far as that is concerned. So to say that they've been put in abeyance or that there will be consultation process, law, society, and the interaction has always scope for interaction. So the concerns of people may be met by interactions, either of a nature which will possibly change anything, possibly only to make people understand what the liabilities are. But frankly, questions of health and life of people, particularly in a country like India, where you have almost 11% of death, which is the highest in the world over, you do need to address as to how to save them. In fact, I remember at a time when I was party to the Good Samaritans case, the Save Life Foundation, and the whole idea was how people who are Good Samaritans should be prosecuted because they're reporting a crime, particularly of rash and negligence act, particularly of death by hit and run or whatever the case may be. So the idea here is to at least save the lives of people, and there have been various judgments also which have addressed this from time to time. I don't think we should be circumspect about a consultation process at all, which has been specified as to say that creates confusion.
Right. let me also take that point to Sidharth Luthra. Mr. Luthra, how do you see these developments? Do you think the government will be able to assuage the concerns of the truck drivers across the country? What is the government saying right now? That if you report the death caused in an accident to the police in time, then you can get up to 5 years in jail. But at the same time, it is a bailable offence. This is the word that is going out to the transporters community. Do you think this will assuage their concerns? There are enough checks and balances in the law?
So the first question that we need to ask ourselves, Ms. Anand made a very valid point that life is sacrosanct and we must work towards protecting life and health. But a more fundamental question arises in these cases is criminalization of conduct, and in this case, not criminalization so much, but penalization of conduct, increasing the penalty, is that the way forward? Singapore has done a variation. They've drawn a distinction between rashness and negligence and treated them differentially. We have chosen not to apply that analysis because the test of rashness and negligence, which we've actually taken, only increased the sentence and taken it from way back from the 1830s, give or take. We've really accepted that that test applied by the English and continued it till date. Having said that, yes, it is important that there should be an incentivization legislatively for reportage. But the point that to be considered is, today you have a section of people who protested about a legislation. The government says they look into it. The fact is the government has not yet notified any of the legislations. It is their prerogative as and when to do it now that they have the assent. But should there have been a deeper comprehension regarding the philosophical moorings of the criminal law? In my view, perhaps, definitely yes, there should have been a deeper understanding on the philosophical moorings of all the criminal provisions that are now being brought in here. And therefore, while protests by individuals are important, but I'm also concerned that once a law is passed by Parliament, should protests itself be the way forward? I mean, after all, what about what discussion took place? What discussions take place in Parliament? That's the place where these discussions should have taken place, rather than for individual citizens to have to hit the streets. And that's the concern I feel. And then when the government believes that individual citizens' concerns have to be assuaged, that can be perceived in two ways. One, that the government is sensitive to the needs of people, and that's what I hope is the case, is so in the present case. But at the same time, there is also concern, should there not perhaps have been deeper thought on some issues like this?
Right. That is an important point. Ms. Anand, do you also agree that there should have been a wider consultation process before this law was passed in Parliament or even brought to Parliament? At the same time, now that the culpable homicide sections related to hit and run cases are being called to question, there could be challenge from other groups regarding other provisions of the criminal laws as well.
Let me tell you this, Parikshit. Any law that is made will be challenged. You just saw today morning the post-environment clearance memo that was done by the government last year was challenged, and it has been stayed also for that matter. So whether it will be challenged or not challenged, most laws when they come into being, and particularly criminal laws which create higher liability, are bound to be challenged. I don't see any way out of that situation. So challenge is not the concern. What is of concern is whether it's a legitimate exercise, whether it is an exercise which should be done. The question is also, of course, a consultation process. Now, in the present case, there has been substantive consultation, not that there hasn't been. Various viewpoints have been taken. A Rajya Sabha committee was formed, which looked into the issues from various stakeholders from all across board, and some of us were parties to those consultations. So to say that it wasn't done also may not be correct. There never is enough. Whenever there is higher liability, there will always be issues. But in the present case, as far as this is concerned, there is one legitimate concern that seems to be there. People do actually fear being literally put down because there has been an accident. Whether that's been a rightful accident or wrongful accident, accident or not is one question. But the point is, yes, mob lynching does happen, and it is known to happen, particularly in India. So the fear of the truckers that is being expressed appears to be genuine. The question is, will it meet within the statute or not? Is one of the questions. So I think a consultation in this regard, which the government has put out, is a very fair thing as long as we are able to cover it in this situation. You can't say one person's health or one person's life against the concern of even a person who's actually had the accident. Either he was guilty, not guilty, that's another question altogether. But you can't have more and more deaths because of an incident that has happened, and that is something which must definitely be looked at.
Right. So you are saying that legitimate concerns must be looked at, and laws are always open to challenge. Mr. Luthra, you want to come in. Do you feel that there are other concerns that the new laws raise which probably require more consultation till the implementation begins?
I'll just want to respond to what Ms. Anand said. The point is, it's not just about protest regarding certain laws. Protest is valid or welcome, is welcome. That's wonderful to know. The issue is more fundamental, and that is this. Ms. Anand talked about a very large figure of fatalities on Indian roads, very valid concern. The point is, successive governments have not bothered to implement and ensure that there is a national highway police, so there is provision under the law. You don't have a national highway police. You don't have a regulatory mechanism. You don't have ambulances parked at highway tolls as they are to be done by the concessionaires to whom the National Highway Authority gives concessions. Similar position has to be applied to the state highways and similar mechanism brought into place. The camber of the roads, the road conditions, we're not dealing with that. We have various safety issues which we've not dealt with, which are going to lead to unnecessary accidents and tragic loss of life. And if our answer is only to increase the penalty, in my view, that does not fit the bill. That's so far as the hit and run cases are concerned. The second thing is, look, today it's a law, and it would be inappropriate on part of any individual as a citizen to say that it is not the law. It has to be enforced. That's all. It has to be notified. The remedy, as Ms. Anand rightly said, lies in the courts. You can challenge the legislation in the courts. But I will only say this. Barring a few select amendments, there is not much to challenge the court because it's really a repetition of what the old law said. There are a handful of provisions. There are some good things like community service, which is being added. But there is, I wish there would have been much more, there would have been a lot more change because that would have led to a lot more positive change as well. So there are concerns in bringing in...
we have to take a short break on that note. Right. Mr. Luthra, we have to take one short break, and I'll return to you and Ms. Pinky Anand. Several important more questions are there on the program. We'll come to you right back after a short break.
I had to leave. I have to.
All right, you're joining us on News Center, and we're discussing the implications of the new criminal codes in light of the protests by truck drivers across the country. With us right now are noted lawyers Sidharth Luthra and Pinky Anand. Sidharth Luthra, you were talking about the concerns. Now that the BNS bills have been passed by Parliament, concerns have been raised by truck drivers. The implementation date is still away. It has to be notified. What are some of the things that you feel the government needs to do now?
So I think till the law is notified, and there have been other instances where laws are not notified because government believes that there is greater consultation required. The fact is that there is some incoherence because you have, as I've said in writing as well, you have organized crime here, but you don't have the rigors of invoking organized crime or the rigors that come with an organized crime provision. You have terrorism here, but you don't have the rigors with the UAP Act, both for starting investigation as also this. And also, you don't have clarity whether this provision will now be investigated by the NIA or by the state police, because otherwise all UAP offences have to go to the NIA, be referred to the NIA mandatorily, whether they take it up as a matter of them and the central government. So I think this level of fine-tuning needs to be done. And the fact that the government has seen that there is some concern among the affected citizenry, because these are the people who actually are the lines of movement of all essential goods. If your trucks are one of the major movement because trains don't go everywhere, flights don't go anywhere. So the roads are the major mover. And the fact is, while this government has done a fair bit to get the national highways and the state highways in shape, that is an ongoing process. Until we have adequate safety ensured on the roads, not only for the persons who are victims of accidents, but also the truck drivers who themselves sometimes become victims of accidents because of the road conditions and the climate conditions and other limitations as a result of road management. So these issues will have to be addressed across the board, not just for this month provision, but across the board. And I hope that this is an opportunity for the government to consider reviewing and tweaking these laws to make them more socially relevant, as also philosophically coherent, to ensure that the presumption of innocence is not lost, that higher penalties don't necessarily make law enforcement more legitimate or more efficacious.
Right. Right. So socially relevant, philosophically coherent is what the government needs to do in terms of these laws. Thank you very much for joining us, Mr. Luthra. Thank you for your time. Ms. Anand, final thoughts to you. What, according to you, is the fine-tuning that the government now needs to do with these laws?
Frankly, let me tell you, Parikshit, my analysis of this would be on a different front. My question is not what the government can do or should do or what the consultation might be. That is, we'll see. But the real question is the liability appropriate? Is it in accordance with what criminal jurisprudence, with accordance with social jurisprudence? Is it something which needs to be dealt with? In India, when you have such kind of accidents and you have the highest, as I mentioned earlier, and you have as a bailable offense, I mean, 304A is a bailable offense up to 2 years as it existed in the erstwhile IPC, the Indian Penal Code. You basically had a different kind of thought process. And we all understand how this really does function. So to have a bailable offense is one part, to have a non-bailable offense is another part. Whether you should have 5 years and or extendable up to 10 years in the event of non-reporting is something which the government might look at. But the question of liability in the first instance, and for it to be non-bailable in a case of rash and negligent act which results in death, which means basically not amounting to culpable homicide, which means that your actions were such that it would cause death, and you should have known that this would cause because of your rational or your negligence. I think in these circumstances, in most criminal offenses of this category or others, and we've had various issues, including, say, let's say what happened with Nirbhaya, which happened in other cases, including motor accidents, including non-reporting, including non-saving of lives. We do have to save lives. We do have to ensure that all lives are saved, and
Right.
that is of concern.
Okay. All right. Thank you very much, Ms. Anand, for joining us. We appreciate your presence on the program. With that, it's a wrap on this edition of News Center. More news and updates continue right here.